So are we ready to go? We have defense counsel here, state here, defendant is present. You guys ready to go?
Yes, Judge. Sean Abuhoff on behalf of the state, along with Kathleen Hogue.
And Frank Briet on behalf of Ms. Clenney. She's present before the court, and also co-counsel Ms. Pugliese.
So we are here for defendant's motion to, or amended motion to disqualify the state attorney's office. I was able to get through a lot of the binder. I've obviously looked through the motions, the response, and some of the case law, but we're ready to go. So defense.
Yes, Judge. You have the binder. I know you've read it.
I haven't read through all of it.
Okay.
Got dropped off a day in advance, but I have
Sure.
read through a lot of it.
Sure. And Judge, our written pleadings say a lot. And so I don't think this oral argument has to repeat everything that's already been delineated in our amended motion and especially in the reply. So I'm just going to highlight some things for you. So the standard is.
Let's go for the standard and why you believe you've met the standard and.
Yeah, so the standard to disqualify the state attorney's office is found in Downs versus Moore. And that is the defendant must show substantial misconduct or actual prejudice. And the case law that interprets what actual prejudice means is more than just an appearance of impropriety. But in the reply, well, in the state's response to our motion, they're highlighting most of their conduct that they've done after what I would refer to as the misconduct of ASA Clenney. The court is intimately familiar with those facts. You send the deposition, so I don't need to rehash the facts of that particular breach into the defense camp. What the state argues is that look at everything that we've done since. We've sealed the V case off. We've restricted access. I would just note that Mr. Quinn's still on the delivery list for pleadings, but we unclick him to kind of wall him off. But what I think is most important, Judge, is Mr. Abuhoff and Ms. Hogue. It's not what they did, Judge. It's what they didn't do. And what they didn't do, which is contained, I believe it's Exhibit A to our motion. Yes, it's Exhibit A. We have a letter. As soon as we realized upon the arrest of Courtney Clenney's parents and the allegations contained within the arrest warrant, it was clear that the state had obtained our work product or attorney-client privileged communications. As recommended by the Florida Bar, as soon as we realized that they were in possession of our confidential communications, we sent a letter addressed to Chief Assistant Kathleen Hogue, Sean Abuhoff, and Mr. Quinnen. That first letter was February 15th of 2023. The response to was sent via email. The response we received from the state was complete silence. They didn't even acknowledge receiving this. Exhibit B, another letter shortly thereafter, February 28th, 2024, same letter, second request. That was received, sent out via email, and the response to that request for having our confidential privileged documents back or communications was silence. Exhibit C, third request. This one came February 10 of 2025. That was after the Chapter 119 revealed the email, the confidential privileged email. We sent the third request again. Ms. Hogue, Mr. Abuhoff, Mr. Quinnen. This third request for our work product and confidential communications again met with silence. So why is that important? The case law that we've talked about in the written submissions talks about substantial misconduct. And what does that mean? The case law doesn't say exactly what that means, but what the case law does say, every case needs to be looked at on a case-by-case basis. So we have to look at the facts of what has occurred in this litigation, and the appellate courts, again, would review that on a case-by-case basis, because every misconduct is, it would, I think, be different. So what we have here is, again, the court's very aware of Mr. Quinnen's misconduct, but Mr. Abahoff and Ms. Hogue, they had a responsibility. When they received these letters, they should have said, you know what, Frank, Sabrina, let's look into this. What exactly is it that you think that we have? They didn't do anything. So I believe their misconduct is by omission, which I think the court should consider in combination with the misconduct of ASA Quinnen in reviewing those materials, not disclosing that to the court, which is it's not a two-prong analysis. It's substantial misconduct or it's not and what the state relies on is the actual prejudice. They're saying, hey, she hasn't been prejudiced. Nobody else has seen this stuff. But I think the analysis that we think is important for the court to consider is, does the conduct of the state by acts or omissions rise to the level of substantial misconduct? And I think it has. They had an opportunity to do the right thing when they received our correspondence. Hey, let me investigate this. What are they talking about? Let's talk to Quinnen and figure this out. Because if there was something done that was improper, they could have nipped it in the bud right there. And they didn't. So I think it's the combination again, the acts and then the omissions on the part of the state. And I think it rises to the level of substantial misconduct. The appellate court decisions, one that the state talks about is Nunez. We think this case is more similar to that of Martinez versus state, where ASAs heard jail calls between the attorney and the client. And in that case, in the Martinez case, the third district, I think it was the third district case. Fourth. In that particular case, that was affirmed on appeal. So it really is very unique circumstances that we're in. I haven't litigated a case of motion either on the side of the state or defense now 25 years. So it's an interesting topic. But I think that what occurred here, Judge, it's an abuse of discretion standard. I think there's substantial record evidence of what occurred and what should have occurred or didn't occur that would support, Your Honor, disqualifying the entire office. And that's what the defense is asking. The entire Miami-Dade State Attorney's Office should be disqualified.
Right, state.
Yes, Judge. So it's the state's position that the defense is misinterpreting the law on this issue. The defense wants to separate substantial misconduct or actual prejudice. But I think the case law is very clear, and there's a reason why quotations only appear around actual prejudice after the term substantial misconduct. And I think that's meant to define. There's a reason why in all of this, the case law on this issue, it only goes on to elaborate on this actual prejudice and what it is, and not just the mere appearance of impropriety. So that's the major part here. And if you look at all the cases that even the defense cites to, they all come about by some form of misconduct by the state. And the question just comes, does it rise to the level of substantial misconduct? And the analysis all comes down to, is there actual prejudice by the defendant at the time? And is there a fear of potential future risk of prejudice? So I think that's the analysis. And I think the defense, certainly wants to look at this individually and point to just substantial misconduct without a definition, whereas all the case law gives it to us. And when you look at those cases, there are plenty of them that are similar to this. You look at McWaters v. State, that the defense side of the Florida Supreme Court 2010, that's where the state actually even listened to jail calls between the attorneys and their client. So there's some form of misconduct that far exceeds what this can even be, but that's part of this analysis. And we have to look to and break down both who are the actors, and what is the prejudice that the defendant faces. And the question here is, does the defendant face prejudice right now in the position that she's in, with Ms. Hogue and myself remaining on the case? And then if that is actually true, then the question would then move to the office as a whole. So I can take, and I would argue, Your Honor, that she does not face any prejudice, and we can break down the two breaches that Your Honor has found to be breaches. The first being the text communications. Defense points to these letters that they've sent to us, the February 15th and February 28th, 2023 letters that were received with silence. That's because after this all came about, we had all of this litigation on the issues of whether or not it was protected material on that computer case, that access case. Your Honor took control of those drives, and it's been in your possession ever since. So the idea of being able to turn back over these items, they were not in our possession. So I don't think we can be faulted for not responding to their letters. The content of those letters are important, though. And that's why McWaters becomes an important case, because in that case, in denying the motion for sanctions or disqualification, the court found that there's no evidence that the substance of these calls provided any benefit to the prosecution or were used in a way that detrimented the defendant. So McWaters goes on to explain that when you look at the context of those communications, there was no detriment to the defendant at that time or any future risk because the calls were what they were. These communications, the only person who reviewed them was Mr. Quinn in their original format. The world has had an opportunity to review them in the arrest warrant and in the search warrants. And what is clear is that those are just discussing the access of the computers. So there is no prejudicial information within those text messages that either myself or Ms. Hogue have seen, or really anybody in the world has seen. And through Mr. Quinn's deposition, he did not even see. It was limited to just that. So from the context of just the communications of those text messages, there's no work product, or I should say no defense theory of the case. There's no strategy concerning the homicide prosecution itself. It merely is the access of this computer. That being said, again, myself and Ms. Hogue did not access this. So as we sit here today, there is no actual prejudice that the defendant faces. It cannot, I don't even believe it rises to the level of an appearance of impropriety, but that, even if it did, that is not enough. But I think the analysis really, and the harder question here is now moving to that, and I termed it in my motion, the Puglisi email. What's clear is that no one that is currently on the state's prosecution team had an opportunity to review this. Mr. Quinn himself did not remember this item, because when Your Honor ordered every part of the communications turned over to you, this would have been included. This is part of that. This doesn't come about until there is a public record request. And that is when the defense sends us, once they're made aware of it, they send us a letter to have us turn it over. Again, it's met with silence because we don't need to respond to it, but we do take action in it. And that's the importance. Myself, Ms. Hogue, has come before this court and stated that we have not viewed it, and we don't plan to view it. And I don't believe anybody in our office could ever view it because I've been able to verify it has been deleted from our servers. So the only person who accessed this is Mr. Quinn. And in his deposition, what was clear from that was the only thing that he remembered from it was the name Mr. Haas, which was their computer expert. And again, going towards that investigation, that separate matter. So when you look at that, that is the Nunez case very specifically. It is a person who accessed, an individual who accessed attorney-client information and the contents, and we have no problem with stipulating that the contents would be prejudicial if the state reviewed it. Mr. Quinn does not remember the contents of it. His only knowledge based on the deposition is the Mr. Haas aspect of it. And so he's also stated in that deposition, we've affirmed he has not discussed with anybody in the state attorney's office the contents of that document. So that goes to the Nunez case, which in that case they found, based on what the court deemed as misconduct, did not rise to the level of substantial misconduct for the office. It did for that prosecutor. They removed that prosecutor, but not the office. So that's why this is not State v. Martinez. In that instance, that prosecutor, not only that prosecutor, other prosecutors heard the calls and were discussing throughout the office. The state has done its proactive work to ensure that the rights of the defendant aren't violated, that the defense team's communications aren't overheard, and we have a filter protocol in place for all of this. Your Honor has been made aware that once, and if Your Honor rules to not disqualify us, we have someone coming to receive these drives to ensure that that is all filtered out. We have no issue with allowing the defense to review those drives prior to any of the prosecution team, or certainly the court, if Your Honor wants to review them. We have no issue with doing that, and I think that's the appropriate thing now that we're here where we are. So we can ensure that there's no more of those text communications that can be reviewed. Concerning this document itself, again, it's been wiped from our servers. No one can access it, and I've been able to verify that. So that's why this does not go to the State v. Martinez case, and this is the Nunez case. Bless you. The other part is that Mr. Quinn has been screened off the case, and that's why I created the analogy of this is different from the Popjoy case, which is a third DCA case from 1992. That case, the office that was taken off of the case, too small to be able to handle that situation. And so the dissemination of information was inevitable. That's not what this is. The Miami-Dade State Attorney's Office is one of the largest in the country, one of the largest in the state of Florida, possibly the largest in the state of Florida. We were able to screen Mr. Quinn to where he doesn't have access to the electronic file. He doesn't have access to the hard file. He doesn't have access to myself or Ms. Hogue. And actually his office is on the far reaches of the state attorney's office to where we don't have to interact with him. So we're able to ensure that anything that he has seen, which the deposition shows that there really isn't any additional information, would not come about or would be discussed with the current prosecution team. So that screening process is an important part and why there is no risk of future prejudice that the defendant might face. So, Your Honor, based on the arguments that I'm making, as the defendant sits here now, based on what Your Honor has deemed breaches, two separate breaches, or one separate breach, but two separate items, there is no actual prejudice as she sits here now with the current prosecution team, let alone the office itself. And then the risk of any future potential breaches or prejudice, we believe that we've taken proactive measures to ensure that that will not be a concern for this court or the defense team.
Yes. Your Honor, it's, how can I put this? The credibility of the testimony by Mr. Quinnen that he just forgot, right? He forgot discovering the linchpin, the evidence that he needed to find the laptop, locate our expert. That is just, that Your Honor can evaluate the credibility of those statements. What the state is trying, and just let's talk more about what occurred. Mr. Quinnen disseminated that information to law enforcement. His testimony was he didn't disseminate it to anybody else in the office. We know that the copy of that email was on the servers, but I do believe, and I do not doubt Ms. Hogue and Mr. Abhoff's representations to the court that they did not view it. But going back, the state's arguing that it's substantial misconduct has to have actual prejudice, but it's an or. And the quotes, I would say, are because the Downs versus Moore doesn't say prejudice. It says actual prejudice. That's the distinction of the quotes. It's an or situation. So for that substantial misconduct, we have to look at what the conduct was of Mr. Quinnen, and then again, the omissions, I believe, on the part of the two prosecutors. In the case of Nespler, which I think the state and the defense have argued in our written pleadings, I guess that's the beauty of the law. We're almost citing the exact same cases, but interpreting them differently. And then Your Honor has to figure out that who's wrong and who's right in a somewhat of a gray area. But Nespler, that's spelled with a K-N-E-S-P-L-E-R versus State 314th Southern 3rd 287. That's a 3rd district case. And they cite to one of kind of the staple Supreme Court cases that addresses this issue, which is State versus Fitzpatrick, 464 SO2D 1185, Florida, 1985. So they talk about how the state is different than a law office. And they say there's a distinction between private law firms and government prosecutorial offices, and that's citing State versus Fitzpatrick. So as a result of that distinction, the Florida Supreme Court has recited that imputed disqualification of the entire attorney's office is unnecessary, meaning you can't do it or you shouldn't do it, when the record establishes that the disqualified attorney, who I would say here is Mr. Quinnen, right, has neither, one, provided prejudicial information relating to the pending criminal charge, which I think that's a tough sell, nor, meaning, and he also has not personally assisted in any capacity in the prosecution of the charge. Mr. Quinnen clearly, right, personally assisted in a whole bunch of capacities, right, in the prosecution of the charge. And again, that's, so what, why is disqualification of the entire office appropriate? Because he, Mr. Quinnen, personally assisted in any capacity in the prosecution of the charge. And that's at 1188 in the Fitzpatrick case. So, you know, we always, when I was in county court and we were all, you know, in county court, the judges, when it's DUI Mondays, there's the state, oh, judge, this isn't my case. This is ASA. So where's he? He's in the hallway, right? Well, you are fungible. That's what we used to always get. Well, you're fungible. You can go ahead and try this case, Mr. Prieto. So it's that distinction. The state is kind of considered their one fungible body. And that's what Fitzpatrick talks about, is that if, I believe it stands for the proposition that if the attorney that was disqualified participated in the case, that's it. You can do it. Right? So I think if you look at you know, the totality of the circumstances of the misconduct by act or omission, I think that your honor would be on solid ground in the third if you disqualify the entire office.
Judge, if I could just clarification, no argument. For the disseminated to law enforcement, that Mr. Quinnen, that was only specifically those law enforcement officers were on the computer case, is my understanding. And if defense knows otherwise, I believe it's just the
I believe that's correct. Yes,
right. So that's a different department than prosecuting the homicide. So I think that is also important to note, because that's also other screening that can take place, that there has not been discussions with those officers, as that case no longer exists. And the only other part would be that the Nespler case is a third DCA case that comes after the Nunez case, and Nespler does not discuss the Nunez case or call into question the Nunez ruling.
Judge, I do appreciate the state has tucked away Mr. Quinnen in the far reaches of the office. But you know,
He was stuck there before.
yeah, well, you know, we have to rely that he's not going to speak to anybody. And I think that that's the fear that the client has and we have as a defense team, that there's nothing to stop the state from, well, we'll end it there, Judge. I appreciate the court's time and the hearing, and
Right.
appreciate the state's arguments.
I think I took all the notes. Let me set it for my ruling. I want to go. It's going to take me a little while to go through everything to write it all out. So let's get 30 days. Then we'll decide one or the other. Okay.
Thank you, Judge.
Than't you, Judge.
Be like a status.
I'm just going to do 30 days to my ruling.
Okay.
So would you like to do July 23rd? That'll be a Wednesday,
No, let's do June.
June. I'm sorry. Wednesday. June 20,
23rd might be on Monday too.
Yeah, it is.
June 25th is a Wednesday.
Okay, let's do Wednesday. Yes,
June
June 25th
25th.
sounds good.
Business.
All right. Then stay. Okay, I'm logging off of Zoom for everybody who's